We are live.
Welcome. I'm Marianne Honeycutt, Dean, Social Behavioral Sciences and the Library, and I'm pleased that you have joined us for the 2020 College of DuPage Constitution Day event. Our theme is the 100th anniversary year of the 19th Amendment. The right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of sex. 100 years ago sounds like a long time ago, but my grandmother graduated from the Chicago Art Institute years before she gained the right to vote. We should consider, beyond the obvious civil rights associated with voting, how including the perspective of half the population influences not only who is elected, but also which legislative priorities are enacted. Attaining full civil rights is a very long, often messy process. As I reviewed the National Constitution Center's exhibit, The 19th Amendment, How Women Won the Vote, I was reminded of the similarity of the arguments associated with the Equal Rights Amendment 52 years later. Christine Kickles will now be joining us with some more information.
Good evening, I'm Christine Kickles, and on behalf of the Constitution Day Committee members, Taya Forst, our chair, Jennifer Charles, Robert Moorhead, and Sally Fairbank, we'd like to welcome you to our special presentation tonight by Dr. Christina Rivers. Before we begin, I have a couple of housekeeping notes to share. First of all your microphones have been muted. However, we do want your questions. And tonight we are using the Q&A box that's available throughout the presentation, so feel free to place questions there. We will take a break around the middle of her presentation to answer some of those, so please feel free to put them in as they occur to you. And also tonight, our session is being recorded and will be available on the College of DuPage's YouTube playlist. So Christina Rivers is an associate professor of political science at DePaul University. Her teaching and research interests include African American politics, civil and voting rights, and the political implications of mass incarceration. She is the author of the Congressional Black Caucus, Minority Voting Rights, and the U.S. Supreme Court, and 2 articles on felony disenfranchisement laws and prison-based gerrymanders. She teaches a course on law and politics at Stateville Correctional Center to a mix of incarcerated and free students as part of DePaul's Inside Out Prison Exchange Program. She also coordinates a think tank at Stateville comprised of alumni of her course. With the think tank and members of the Chicago Lawyers Committee for Civil Rights and Chicago Votes, Dr. Rivers was involved in the writing and passage of Illinois' Re-Entering Citizens Civics Education Act, Public Act 101-0441. This law mandates voting and civics information as part of the exit process from the state's Department of Voting and Civics Information, as part of the state's Department of Corrections and Department of Juvenile Justice. She also volunteers with Chicago Votes to provide registration and voting access to detained citizens at Cook County Jail. Her current scholarship is around voting access for eligible pretrial detainees, felony disenfranchisement laws, and prison gerrymanders. So please welcome with me, Dr. Rivers.
Thank you, everyone. It's a pleasure to be here. I'd like to thank Professor Taya Forst for inviting me to speak on this topic. I also thank Dean Honeycutt for her support of this event, and I thank the great team for making it happen. And I thank all of you in the audience for being here this evening to hear this talk. As you can see, the title here, the 19th century into the 19th Amendment, Dreams Fulfilled, Dreams Deferred, and Work to Do. This is definitely a time for celebration of the passage of the 19th Amendment, but as with many other successes in the states, especially with respect to voting, there's always work to do, and there's always has been a history of deferral of some of those dreams that were intended when the papers were signed and the ink was drying. So Dean Honeycutt, I'm very glad that you mentioned your grandmother, and Jen, you can go to the next slide. We didn't plan this, folks. We didn't coordinate this. But as I was putting this talk together, my mother came to mind. She comes to mind a lot. But in part because as I've been thinking about the centennial year, the centennial celebration of the 19th Amendment, my mother would have been 100 this year. And so I just sort of wanted to start with her. She was an avid voter, and so I wanted to start with her as this picture of her as a future voter. And she very much inculcated the value of voting as I was growing up. It was never a matter of if you vote, but when you vote. She was born, next slide, please, of an equally avid voter. This is her mother, my grandmother, who liked to joke that she voted early and often. And she is an example of the dissonance with respect to the 19th Amendment and the fact that it was not immediately, not everybody could take advantage of it when it was passed. And so my grandmother was living in San Antonio in 1920. And at that time, she would have been about 30 years old. So certainly of age to vote. You had to be 21 at the time to vote. So when the 19th Amendment passed, she would have been a newly enfranchised female voter. Unfortunately, she was not able to vote in San Antonio because of her race. And she was also not able to vote when she and my grandfather and the rest of their family moved to St. Louis. And so she was enfranchised by dint of her gender, but disenfranchised by dint of her race. Next slide, please. So I always like to throw this picture in here as well. So they all hopped in a Tin Lizzie. Grandma, grandpa, and the 4 kids crammed onto this car that you see here. And moved to Chicago in the early 30s. They settled into the Bronzeville and Woodlawn neighborhoods. And by my grandmother's account, she quickly joined in with civic and teachers organizations. She had gone to Fisk University to be trained as a teacher. And by the mid to late 1930s here in Chicago, she was a card-carrying Democrat. I have seen the card. I thought we still had it. I was looking around some of my old papers, and maybe another relative made off with that, but I've seen that card. My grandmother's partisanship was likely influenced by U.S. Congressman William Big Bill Dawson at the time. He was a handful of Black congressmen, U.S. congressmen, who during the New Deal convinced Black voters in the North to shift their party from Republican to Democrat in support of the New Deal. He was instrumental in convincing the shift in partisanship on the part of Northern Blacks, along with other Northern Black voters at the time, again, in support of the New Deal. So again, my grandmother voted early and often, as we say here, for the rest of her life. And this photo here on the right was taken in 1972. This would have been the last year she had voted in a presidential election before she passed away. I am convinced that somewhere along the line, she is still voting. I hope this does not get me in trouble with anybody. But again, she was a really avid voter and a woman who took full advantage of the 19th Amendment's provisions. She just had to wait 10 years to do that. So I always like to start out with this. Next slide, please. So just to give a brief overview, in the early era of our democracy, it was not a universal suffrage moment by any stretch. And so you can see this list here of restrictions on voting. And so for many of us here, if we attempted to vote during the founding era, in the early era of our democracy, we would not have been able to vote. Those restrictions that I've written here in orange, I kept them in orange in part. I left the male, certainly women can vote now, that's why we're here today. But I just left that to sort of point out and acknowledge the 19th Amendment that should, in theory, be in black. But poll taxes still exist implicitly in certain ways, and felony disenfranchisement laws exist in 48 out of the 50 states. And so there are still these founding era restrictions on voting that impede many, many voters. So the passage of the 19th Amendment was a victorious end of the women's suffrage battle. I should say battles, because historically there were about 3 eras of women's suffrage, starting in Seneca Falls in the 1840s, late 1840s, and culminating with the passage of the 19th Amendment. However, as was the case with my grandmother, very likely my other grandmother, who was living in Charleston, South Carolina when this amendment was passed, also was probably unable to vote until she arrived in Chicago in the 40s. And like many other Black and other non-white women, the 19th Amendment did not automatically open the doors of the precincts to every woman in this country. That process took several more decades and much more struggle. And it's, of course, as we all know, still has not yet led to equal representation of women among elected officials, irrespective of race. So there's still major gaps in electoral victories with respect to women and closing that gender gap with respect to elected officials. So again, the latter two restrictions are still very much at issue now. The poll tax issue is implicit, but in some levels still there. And the impact of felony disenfranchisement is much broader, as I will delve into later on in this talk. Next slide, please. Thank you. But before I go further with this, I'd like to back up a little bit. My training is as a political scientist, but I'm very much a political historian as well. And so I always like to back it up. And I'd like to, for folks I'd like to review some of the many laws and Supreme Court decisions that have been passed with the goal of protecting and enhancing voting rights in the US. And this isn't even an exhaustive list. It's just sort of a list of some of the primary laws and decisions that have been rendered and legislated and rendered on behalf of voters in this country. The fact that so many laws have been passed indicates great progress with respect to voting rights. Equally, if not more importantly, however, it indicates the tenacity of the battles over voting rights and representation, which are at their base battles over power and influence. These battles are proving eternal with shifting fronts, and victories are often swiftly followed by retrenchment and retrogression. One thing I also wanted to point out was once the 19th Amendment was passed, women have had pretty much unfettered access to the ballot based on their gender, with respect to gender, I should say. There's been no more litigation. Women did not have to go to the courts, either state or higher up, to secure their right to vote. Those battles did end with respect to gender. They did not end with respect to race. And so again, to the extent that we're talking about non-white women, many still had to struggle to vote based on their race. So there is that overlap. Okay, next slide, please. So another reason I wanted to back up is just to talk a little bit about the history of the suffrage movement in this country, and to highlight some of the women who were involved who pushed for suffrage, but also pushed for abolition. And so it's important to emphasize that on the whole, oops, sorry, went too far past my notes. On the whole, the battle for women's suffrage and political voice, how long it's been waged. So some of us, maybe many of us, are aware of the first women's suffrage convening that happened at Seneca Falls in upstate New York in 1848. So that's pretty far back. This was a convening mostly of women, primarily white women, who were living up in that part of the country. Frederick Douglass, however, was invited to be a keynote speaker. At that point, he had already established himself as not only an ardent abolitionist, but as an ardent suffragist and a proponent of voting rights for everyone, regardless of their gender and regardless of their race. It's far less often taught, however, that many of these early women suffragists, Black and white, were also ardent abolitionists. So there's a strong intersection of the early suffrage movement with abolitionism, again, amongst both Blacks and amongst whites as well. And especially in this early period, in this antebellum, obviously this antebellum period. And so we're familiar with Frederick Douglass. Some of you may be familiar with Sojourner Truth and her famous speech that posed the question, ain't I a woman? Am I not a woman too? When people were talking about women's suffrage, Black women were often excluded. And so part of that speech was really going at this notion of, I too am a woman. If we're talking about enfranchising women, we need to be talking about everybody. And so people like Sojourner Truth, Frances Ellen Watkins Harper, were universal suffragists who called for the enfranchisement of both women and African Americans, men and women. But of course, they were doing this at a time when women and enslaved Black people were constrained by both forms of chattel status. What I mean by that is women, period, lived under chattel status in the US at this point. They had no legal personhood to speak of. And so that's one reason that they weren't allowed to vote. Enslaved women and men were also stripped of their personhood and of their humanity, as well as their right to vote. The Dred Scott decision of 1857 eventually determined that all Blacks, whether enslaved or free, had no legal personhood. And so the grounding under the suffrage movement for African American women and African Americans, period, was quite different from the larger suffrage movement. Put otherwise, suffrage was really at the core of political personhood for women, race notwithstanding. But for Truth and Harper and Douglass and those for whom they advocated, suffrage was at the core of Black humanity as well as at the core of their political personhood. So again, there was this double layer. For Black folks in this era to fight, to vote was not simply political, it was existential. And so for these reasons, the suffrage movement was most often universal amongst Black activists here, where the push was to enfranchise Black people, period. There was never as much gender division amongst African Americans as there was in the mainstream suffrage movement, in large part because white men already had their right to vote. They didn't have to fight for that, or their legal personhood along with that, where Black men, of course, were also fighting to secure their right to vote. And there, in many free states, there were enfranchising statutes as well as the local level. And so free Blacks in many areas were also disenfranchised, even though they weren't enslaved. Next slide, please. Okay. So I wanted to bring Ida B. Wells to folks' attention here. Ida B. Wells is known for so many things, but she also was an ardent suffragist, along with being a desegregationist and, of course, an advocate against lynching laws. So Ida B. Wells Barnett and her colleague Mary Church Terrell were key advocates of women and universal suffrage after emancipation. So they didn't have to be abolitionists. But they still fought for both women's suffrage and universal suffrage after emancipation. At this time, the women's suffrage movement had greatly expanded across the board. At the time also, however, and unfortunately, it became much more racially divided and exclusive. This was because there was so much frustration, understandably, among mainstream suffragists and a suffragist period over this. It was a zero-sum prospect. It became very clear that Congress was going to write an amendment that would have either enfranchised freed Black men or women, but not both. And so once that zero-sum prospect became apparent, there became much more division in the suffrage movement or movements, both with respect to race, both between whites and Blacks, and I should say primarily that. Not every mainstream suffragist opposed Black suffrage, but there were quite a few that did, where the perception was that white women who ostensibly also were more educated and were seen as more qualified should have gotten this right to vote first. And Elizabeth Cady Stanton, who was a stalwart, one of the key pillars, the two key pillars of the women's suffrage movement at this time, was quite vocal about this. And so while that was happening, there became this split, this sort of parallel activism between Black women and white women around suffrage. And so again, while Ida B. Wells Barnett is known mostly, I shouldn't say mostly, but it seems to be, this is what I hear the most when I hear her name mentioned these days, that she's known mostly for her advocacy of anti-lynching laws. Both she and Mary Church Terrell fought ardently against segregation and they fought for suffrage. And of course, they recognized that with the right to vote, one could more effectively fight segregation laws that were increasingly becoming solidified in the South and elsewhere. Wells Barnett was a founding member of the Niagara Movement, which is a precursor to the NAACP. And both of these organizations were strong supporters of women's suffrage and of protecting voting rights in the South. Terrell and many like her were also involved in Black women's organizations at the time that advocated around these issues, along with access to quality education for Black children. So next slide, please. So I just wanted to show this image of the March on Washington and this image of Delta Sigma Theta sorority, which was the second African-American sorority that was founded in 1913 at Howard University. Just a couple months after the founding of that sorority, they marched. They were expressly uninvited by the mainstream suffrage movement, but they marched along with other Black women's organizations at this historic women's suffrage march in Washington. It should be noted for those you don't hear this quite as often, but it should be noted that women were the first to organize a massive march like this at the nation's capital. Many people tend to think that that didn't start until the famous civil rights movement in 1963, but no, women started this party 50 years prior and established what would eventually become a long tradition of such marches. I'd also like to note that many of these women were harassed and assaulted at that march by male anti-suffragists and by law enforcement. Some of these women were arrested, some went on hunger strikes, some were brutally force-fed to force them to end that hunger strike. There have been many documentaries about that particular dimension of the women's suffrage movement. There's a new documentary out on it called The Vote, quite simply, on PBS. And it's currently playing, I think. And it's got this tagline, this great tagline: women weren't given the vote, they took it. And that certainly was demonstrated at this march, not only by the tenacity of women to appear like this in public, at a time when it was not considered by polite society to even be proper for women to appear in public, much less speak in public. For women to have taken the initiative to collaborate this massive march as far back in 1913 is quite quite commendable. So I just wanted to show these particular images and to again emphasize that Black women were involved in this. They weren't invited to it, but they were involved. Several organizations, both this sorority here and then also this picture, the other one, I don't know if people can read it, is from the Women's National Baptist Convention. So next slide, please. And so now, and here's where I'm a political scientist and not a historian because I'm jumping way ahead several decades, my apologies. I wanted to talk a little bit about the role of women in the Voting Rights Act. We've been hearing a lot recently about the Voting Rights Act after the passage of John Lewis, of US Representative John Lewis, and really how he was an iconic image of the Voting Rights Act and how he physically suffered for the right to vote. And not to take away from his accomplishments at all, not one iota. It is necessary to point out that women were in this fight as well with respect to pushing for the Voting Rights Act. And so although the term suffrage wasn't commonly used by the 1960s, suffrage was at the center of the civil rights movement, along with the passage of the Civil Rights Act. And so some of these images I wanted to point out here were of stalwarts like Fannie Lou Hamer, who argued very passionately for the role of the Mississippi Freedom and Democratic Party in 1964 at their Democratic National Convention. People like Ella Baker, who's to her right there in that picture, and then Eleanor Holmes Norton in the middle, who later became one of the first mayors, if not the first mayor, of Washington, D.C. Or no, I'm sorry, she was a delegate, congressional delegate for Washington, D.C. in Congress. These were all profound voices during this period where they were really focusing not solely on the Civil Rights Act writ large, but on the Voting Rights Act, which is sort of the last effort that was made of the civil rights movement. They sort of saved one of the biggest accomplishments until last. I'd like to point out that Fannie Lou Hamer suffered an absolutely savage beating by Southern law enforcement after being arrested one of many times for her mobilization efforts. It slowed her down. It did not stop her. And she continued as this voice for the rest of her life. And so thanks to the Voting Rights Act, voter registration, Black voter registrations in the South went from the single digits, which had been suppressed for decades by Jim Crow type devices. It was not until the passage of the Voting Rights Act, 45 years after the ratification of the 19th Amendment, that Black women in the US had a full and largely unfettered right to vote, because those literacy tests, those poll taxes, those interpretation tests, those invasive registration requirements were all rendered unconstitutional. Now, in some of those cases, there were Supreme Court decisions that had stricken some of those provisions down, but the Voting Rights Act really tied the bow onto that. And so the second person really is an example of this. She's sort of a living example of those successes. Barbara Jordan is a legacy of this victory. She was elected to Congress in 1972 as the first woman, period, to be elected to the Texas legislature on her own. I'm sorry, to the US Congress on her own, as opposed to in the past, women who held those offices were usually spouses who might have inherited or were appointed to that office if their spouse was a congressperson.
Dr. Rivers, we are at almost 7:30, so
okay.
We'll be taking questions in a few minutes.
Okay. Jordan was also the first Black person elected to the State House since the 1880s. And so I just wanted to point out these iconic women in this struggle who often don't get sufficient attention for this, and also point out how long it took. So I just wanted to point out this final slide. We now enjoy many expansions. Can you do one more slide, please? Of the Voting Rights Act. And we can always back up to this, or many expansions of our voting rights, in large part thanks to the Voting Rights Act. And then one more slide, and then I'll stop. There are many restrictions that have appeared over time as well. So next slide, and then I can stop here. So the good news is voting rights have been expanded a great deal. The bad news is the struggle still continues. So I will stop on that.
Thank you so much, Dr. Rivers. I just wanted to point out you were in class earlier, so you couldn't join us, but you actually answered one of the questions from earlier when you showed the march with the Delta Sigma Theta. So Thank you very much for that. I thought you would want to know that.
Thank you.
I'm Taya Force, and I'm going to help moderate with the questions. One question that came through was, how were your grandparents specifically disenfranchised in both San Antonio and St. Louis?
Well, typically the way African Americans were disenfranchised is they would have to take often a literacy test in most former Confederate states, and more often than not, they didn't pass the test, even if in reality they passed the test. There's a great documentary out about that shows this, called Mississippi and the 15th Amendment. It's old, it's a little hard to find. It was produced in the 60s as these things were still happening. But just really through very discriminatory uses of devices like literacy tests, interpretation tests. Some people simply couldn't afford a $2 or $3 poll tax. That was considerable if you just didn't have that, or were in debt, which many poor Blacks were, and others, not just Black folks, but others as well. In some cases, people were essentially terrorized out of voting. And so in my grandmother's case, she very likely had to take a literacy test that she was just told she didn't pass. That was the most common way of disenfranchising people, was through the literacy test.
Excellent. We're getting in some great questions, and because I know that these are things that you are really passionate about. Was the issue of women's suffrage, Dr. Rivers, fought between the political parties? Was one party in favor of it while one was not?
Yes and yes. So it's kind of a trick question. It depends on region. The Democrats were largely in favor of women's suffrage. Republicans a little bit less so because they were in power at the time. The Democrats, the Democratic Party in the South had largely been disenfranchised as based on its role in the Civil War. And Republicans very wisely knew if they enfranchised women, they would be enfranchising a lot of women who would vote Democrat. Whereas if they enfranchise free, liberated freedmen, that they would just be enfranchising men who would then be very loyal to the Republican Party, as Black voters were for the next several decades. And so it was a tactical decision. And so in the North, you had more support of women's suffrage. In the South, by Democrats. In the South, not so much. In the South, there was quite a bit of resistance to women's suffrage, in part because Southern society, at least from what I've read of it, was much more patriarchal, and still subscribed very much to this what's called doctrine of separate spheres, which was sort of the cultural moray of the time, which basically said that the realm of the public, of politics, of economics was the realm of the man, and that the realm of the home, it was the realm of the woman, and that women didn't really need to kind of sully themselves with entering into this particular realm. So Democrats in the South were not nearly as universally in favor of women's suffrage as they were in the North. There were obviously exceptions to that. So that's why it's kind of a yes and yes. A lot of it just depends on region.
Thank you for that clarity. Dr. Rivers, we have a participant that says, thank you for this thoughtful presentation. It seems that women, specifically Black women, have had a long tradition of fighting for rights. Can you expound as to why that has not translated into Black women's importance in the political process and or holding office?
I would say importance or maybe success in holding office. It's difficult for women to gain public office. Running for office is expensive. And even now in this day and age, it's much more difficult for women to raise funding. This has nothing to do, I'm not talking about racial differences here. It's just far more difficult for women candidates to get the kind of massive funding that male candidates still get. Typically, candidates of color, Black and Latino candidates typically also tend to generate less campaign financing than white candidates. And so if you're a Black female candidate, that lessens the likelihood that you would be able to score some of that major funding that white male candidates would get. And that's unfortunate, and it's much more consequential now since the Supreme Court's decision a few years ago to sort of take the lid off of the various limitations that were on campaign financing. And so what that means is those who have the capacity, the candidates that have the capacity to raise money, there's really almost no limit to this. And so it creates much more of a disproportionality. So that's, you need money to run, to run an effective campaign, especially at the national level. There are more Black women that are winning elections to local legislative office, for instance, city council office. There's an increasing number of Black women who are being elected to state office and to mayor, to mayoral office. But it's very difficult for Black women and women, period, to win national office. I mean, let's think about it. There's barely 20 women in the Senate. I don't want to editorialize too much, but that just doesn't make any sense at this point in our lives. 100 years after the passage of the 19th Amendment, and we're not even a quarter of the Senate.
Thank you, Dr. Rivers. I wanted to just let Jose know that because you're going to speak directly to people who are incarcerated in part 2, I'm going to hold off on this question. So I just wanted to make sure he wasn't disenfranchised with our process. So Dr. Rivers, Pam asked, in the United States, several individual states granted women the right to vote before it was approved by the federal government. Why do you think these states gave women the right to vote before the federal government?
I think in many of these states, these were Western states, And this was in some cases starting, if I remember this correctly, back in the late 1800s. And as people were going west, young man, to use that crazy phrase, that silly little phrase, that was literally go west, young man. It was mostly men who were going west. And of course, we've all seen enough dusty, corny, cornball Western movies and seen all the scenes about how men misbehaved, right? They were always getting into barroom brawls. There was this whole notion that the West was sort of this lawless frontier. And to some extent, that was true. And so some of these territories, for lack of a better term, would lure women to come out there and settle by offering them the right to vote. There was an interest on the part of some of these territories to get more women out there so that these men would settle down, marry somebody, grow up, and have something better to do. And I'm speaking, crudely here, but this is really what was at the base of it. To get a life, to grow up, to stop hanging out in the bars and drinking and fighting, and to become lawful, honorable, upstanding citizens. And the thought was we needed women to do that. The irony of some of the opposition to the women's suffrage movement, and you saw this argument both on the part of opponents and supporters, was that there was this belief that women, because women were seen as virtuous, as honest, as stewards of the home, that they would clean up politics if they were allowed the right to vote. That same argument was sometimes used to say, because women are so virtuous, they shouldn't be dirtied up by politics, so we should not allow them the right to vote. So it really kind of ran both ways. But often that benefit, that perk, was extended to women to convince them, especially women who would have wanted to vote, to move out west and to settle out west. That's most of the readings that I've seen on that.
So we're just at 5 minutes, Dr. Rivers. I think we'll have time for 2 more questions. The first one is, what were the immediate ramifications of granting women suffrage in 1920?
It's funny. By many accounts, the immediate ramifications were quite simple. They voted. And the world did not spin off its axis. If you read some of the writings of people that opposed women's suffrage, and by the way, there were women who opposed women's suffrage, you would think that the world was going to spin off of its axis, that up was going to become down. I mean, it was really almost a hysterical panic and fear of women having the right to vote. And women very quietly started voting, and it was nothing cataclysmic. Depending on some sources that I've read, I've read expressions of disappointment, in fact, that women did not vote as strategically as was hoped. I've read literature that suggests that women voted, in fact, somewhat passively, where they tended to vote in the same way that the male head of household would have voted, whether this be their dad or their husband or their big brother. And so that their vote really became kind of an extension of the male head of household until, in part, the New Deal, and then again until the 60s, where women really started to sort of assert their political strength much more openly, starting during the 60s activism eras. And so I would say the short answer to this is they got their ballots and they voted, and they began to vote very consistently, and it just grew over time, but nothing dramatic happened in those early years.
Thank you so much. And then we have just time for one last question, but I do want to encourage people to continue to send the questions up. We will have a second Q&A session with Dr. Rivers after her answer to this question and her second part of her presentation. Dr. Rivers, you mentioned people of color having a harder time raising campaign funds. Do you think that systemic racism and lack of access to a network directly affecting fundraising? If not, what is the reason behind the disparity?
I think that systemic racism is the reason behind a lot of things. I'm somebody that happens to believe that there is still such a thing. I think that there are still people who have a personal bias against Black candidates or candidates who are not white, and we see that borne out in voting behavior. We see it on some level borne out in surveys. It's a difficult thing to capture because very few people are going to admit that, correct? You know, when you talk about allocation of funding that a party would give to a candidate, you know, I don't think that is much of a problem. I think a lot of the problem comes from just the willingness of private donors, especially donors with large amounts of money, to have faith in political candidates who are women, or who are Black women, or who are some other historically member of some other historically marginalized group. It takes a long time to work through those biases, and for those with money, either small amounts or large amounts, to gain the confidence to contribute to those campaigns. And again, the gender gap, period, in campaign finance is significant. Now, I haven't followed it as closely in recent years as I have in the past, and so it could be closing, but it is significant. And so women candidates tend to get a good amount of donations, but they tend to be smaller, you know, $50, $100, $200. Now that adds up, as you know, we saw Bernie Sanders doing this with his campaign. But it is still typically pretty difficult for women candidates and then women of color to just gain that. And I think a lot of that still has to do with people needing to retire some of the predispositions they would have that these are not qualified candidates.
Excellent, Dr. Rivers. We've already started to have questions come in for part 2, so I'm going to go ahead and hand it back over to you to begin your second part of your presentation, and I'll return when you're ready.
Okay, I'm ready. Okay, so part 2 is we've come a long way. Boy, I'm going to date myself here. So if anybody remembers the Virginia Slims ad from 1972, I'm going to do this. We've come a long way, baby, to get where we're going today, but we still have a long way to go. And one of the primary challenges with respect to voting, where this does affect women, is incarceration. And so now I'm trying to get myself on the same slide that you're on. Is incarceration and, oh, I'm sorry, just give me a minute here to get where she is. Work to do. Got it. And so I want to talk a little bit about the dynamics of incarceration with respect to voting and gender. And so we've been hearing a lot about mass incarceration for many years now with the advent of Michelle Alexander's book, The New Jim Crow. But it's taken a few years to hear about the intersection of mass incarceration and democracy. And I thought it was interesting when Alexander, when this book came out, she opened with a vignette on the story about a young man who had been incarcerated. He with a felony conviction, he's out, but he's no longer able to vote. And so when I opened that up, I was like, yes, somebody's finding and writing about this. And not to take away from the book, it's an excellent book, but it never really got back to that issue. So I want to talk more about that here, and it is finally coming to light in many ways. Black, Latinos, and Native Americans are disproportionately arrested and charged and convicted. They don't commit crimes at much different a rate than whites, but they do tend to be disproportionately arrested, charged, and convicted. So what does this mean? We currently have 750,000 folks in jail, over 90% of whom are eligible to vote, but they can't vote because while detained pre-trial, they just don't have access to the ballot to register or to actually vote. And many people are in jail simply because they can't afford to bail out while they're awaiting trial. We currently have 2.2 to 2.3 million Americans are incarcerated. 48 states disenfranchise people who are incarcerated and serving out a sentence for felony conviction. And then some jurisdictions include incarcerated people in their electoral districts when they're drawing electoral districts. These are referred to as prison gerrymanders. The two states that do allow people to vote while they're incarcerated are Vermont and its neighbor, Vermont and Maine. And that's not surprising. Vermont and Maine, you know, they've always done things a little bit differently, right? And so they've allowed incarcerated people to vote since the mid-1800s. Puerto Rico, the territory of Puerto Rico also allows incarcerated people to vote while they're serving out their felony conviction. But for now, for the most part, 2.2 million people who are incarcerated right now cannot vote, the vast majority. Another 4.5 million Americans are disenfranchised after incarceration, and there's a patchwork of limitations and timelines. It really differs greatly based on the state. And until last month, in the last 2 years, there were 4 states left that disenfranchised people permanently. Iowa last month became the last state to repeal permanent disenfranchisement. What's important is that women, the incarceration rates for women are growing more quickly. Rates are growing more quickly than they are for men. There are far more men who are incarcerated, but just in terms of rates of growth, women are being incarcerated at higher rates than men for right now. And I don't have the full explanation as to why that is, in part because there's a lack of data on this, as I'm pointing out here. There's often a lack of focus on this issue. And in many cases, it's just hard to get data and access to incarcerated women, period, even for things like programming. So these are problems that are finally coming to light. And again, so there's this intersection of incarceration, growing incarceration rates of women, which, you know, again, is sort of this example of work that we still have to do with respect to the full implementation of the 19th Amendment. So next slide, please. And I apologize for this slide. It's a beautiful slide, but it's probably hard to read. For folks who want to see this, this is off of a website called prisonersofthecensus.org. And it's called The Whole Pie, Women in Mass Incarceration, The Whole Pie. And so I think most of you can see the numbers here of how many women are locked up. So it's a total of about 200,000, and roughly half are in jails, the vast majority of whom are awaiting trial. If you're sentenced to convicted and sentenced to less than a year, often you'll serve out that sentence at a jail. If your sentence is more than a year or 2 years, then you'll go to prison to serve out that sentence. So you can see it's an even split between women who are in jail and women who are in prisons, and then a smaller percentage for people who can't see this. The purple wedge is for youth, so women under 18, 6,600. 7,700 women are in immigration detention, and then about 16,000 women are in federal prisons and jails, as opposed to state prisons and jails. And so this is as of 2019. Next slide, please. So I think I saw a question about the derivation of felony disenfranchisement. It comes out of this concept of civil death. And this was originated in the ancient Greek, or original democracy, at least that we know of historically, where, you know, that was one of the first civilizations where people had a right to contribute their say in their government and how they were led. And so in early Greek democracies, the perception was if someone committed a crime against another person or a crime against society, that part of their punishment would be the revocation of their civil voice, and that they would be disenfranchised under this principle of civil death for a certain time, not permanently. And then once they have served out their punishment, their voting rights, their political voice would be restored. They would be revived, if you will, resuscitated back to their sort of full civil humanity. Certain medieval societies in Europe inherited this principle. It really kind of reflects Rousseau's social contract theory. And the founding fathers of this country also imported felony disenfranchisement into the colonies and then eventually into the states once those colonies became states. So there's deep roots to felony disenfranchisement laws. So some of the outcomes is that they do reinforce some of these founding era limitations on popular democracy. It was less of an issue when our incarceration rates were lower. It's much more of an issue given the explosion in our incarceration rates. And then you get the racial animus comes in. These early felony disenfranchisement laws didn't have a racial animus. And in ancient Greek, they were all Greek. Same thing in medieval Europe, they were all European. But by the time we got to the post-Civil War era and the Jim Crow era in the US, in the South, they took on extremely racist animus. And this was a way to prevent these newly enfranchised Black men from voting. If you increase the type of actions that if you criminalize an increasing number of actions, and if you target Blacks to be arrested and convicted of those actions, then this was a very effective way at depriving them from voting. And often these felony disenfranchisement laws in the Jim Crow era South were for life. So even if you served your time, you couldn't vote again. It was extremely effective. In the North, there were certain states in the North that imposed and strengthened their felony disenfranchisement laws as a way to control the votes of immigrants, whom many Northerners didn't trust with the vote. So there was a strong dose of xenophobia in some of these Northern felony disenfranchisement laws. And so what ends up happening is this reinforces this interdependence of law and race and power, and it reinforces the political, it's a way that criminal law can reinforce the political suppression of racial minorities, especially again, since you have this racial disproportionality, not so much in who's committing the crimes, but who is being arrested and convicted of those crimes. So next slide, please. Let me catch up with you here. Okay, so what ends up happening, to the extent that you have racially skewed incarceration rates, which come with felony disenfranchisement, which are also racially skewed, you get skewed representation. And so, you can see the disproportionality here in some of these numbers, where you have 7% of Black folks who are disenfranchised compared to 2% in the overall population. And up until 2018, for example, in the states that I've listed there, Florida, Kentucky, Tennessee, Virginia, and Florida really stands out, up to 25% of Black Floridians were disenfranchised by that felony, their permanent disenfranchisement law, until that was changed in 2018. This is astounding. The Illinois demographic, African Americans are 55% of the incarcerated population, but only 15% of the state population. And so that is reflected in their ability to vote, or their inability to vote as well. So there's these profound disproportionalities. Now, one thing I do want to add, since we're talking about Illinois is one of about 8 states that automatically restores voter eligibility immediately upon release from the Illinois Department of Corrections. So folks do have to go re-register, but their eligibility is restored. Unfortunately, a lot of people don't know this, or they're told otherwise. So there's a knowledge gap. And again, Iowa just last month repealed, it was the last state to repeal its permanent disenfranchisement law. Prior to that, Florida, Kentucky, and Alabama all repealed their laws in the last couple of years or so. Next slide, please. Okay, so what's really, I think, most fascinating, maybe for me as a political scientist, is that civil death does not equate to civic disengagement by any stretch from what we're learning. So these numbers are from a survey that students that I work with at Stateville compiled themselves and administered themselves. And it really had, yielded some extraordinary results. And you can see how many had voted prior to incarceration, and depending on the year, sometimes in jail. Cook County used to do jail voting fairly regularly in the 80s through the early 2000s, and they're doing it again, which I'll get to shortly. very high rates of responses in terms of saying that they would vote if they could. But only about 40% knew that their eligibility is restored, and only about 20% knew how to regain that eligibility. So you see this high rate of interest in voting, but it's sort of canceled out by low knowledge of how to regain that eligibility. One thing I'd like to point out is this overall conclusion of high interest in voting completely disproves conventional conclusions, particularly in my field of political science, that justice-involved individuals are politically apathetic. This is just not true. We're seeing this here, and we're seeing this in other states. So for me as a political scientist, this is a good news thing, right? We like to see voter engagement. Next slide, please. And I won't belabor this one, but this is just similar examples from a larger survey in California that I think was returned by about 5,000 people. So very, very similar outcomes in California, very similar. There's a third survey that is out there that the Marshall Project has put out. And as of February or so, they had gotten about 7,000 responses from incarcerated people from across the US. Theirs was a much bigger survey, but they again yielded very, very similar results. So, you know, I'd ask myself, how is it that political science and others have had it so wrong for so long about a lack of political engagement amongst people with a criminal history, or even an arrest history where they weren't charged or they were found innocent? And I think one answer is that scholars, we have never asked those who are directly impacted. Many of the studies of this problem are done from a distance through second and third hand testimony surveys, or maybe talking to people who are reentering. We tend to treat folks who were incarcerated as subjects of, not participants in the production of knowledge about this issue. We didn't really take the time to learn directly from them, and so our findings about their engagement has been skewed until that has started to change, and now we're really seeing where we were wrong because we're having direct conversations. More of us are having conversations with people in this position. So next slide, please. Yes. So Illinois, Illinois is a bastion of democracy. Sometimes people will say too much. So Illinois has done many things to address some of these voter challenges, some having to do with incarceration and some not. But what I really want to draw our attention to here for this talk is there were two laws. In the introduction, one was mentioned, the Reentering Citizen Civic Engagement Act, which provides voter education to people as they leave the Department of Corrections and as they leave the Department of Juvenile Justice, as one of their many exit workshops that they all have to take. And then PA 101-0442 was passed at the same time, mandates voter registration access to pretrial detainees. So it now makes it a law that jails have to offer voter access and registration access. And in jurisdictions that are large enough population-wise, they have to actually create a voting precinct at the jails, which is what is happening again now at Cook County Jail. We also have two bills. There are also two bills that have been put forth recently, I think last fall, one calling for a repeal of the felony disenfranchisement law here in Illinois. That's a state law, and another one that's calling for a constitutional amendment to repeal that law, because felony disenfranchisement is governed both by state law and it's in the Constitution as well, I believe. There are also, and there's not enough time today, but there are a lot of other states that are having similar moves. Their question came up about Florida, so I'm happy to talk about that in the Q&A. But Florida, Maryland, Texas, Louisiana, Georgia, Mississippi, Alabama, California to some extent. There are many other states that are now finally addressing this issue of felony disenfranchisement and pretrial detainee challenges and prison-based gerrymandering. It's all kind of really gearing up now. So I think we're really kind of at the beginning of this. I will brag about Illinois. These two laws that I just mentioned are the only such laws like this that exist in the US. So we got it started, and we're hoping that other states will pass similar laws. So next slide, please. So I just want to close this out with a discussion of just a little bit of an overview. It's been mentioned that I've been doing work at Cook County with organizations called, one called Chicago Votes and the other one Chicago Lawyers Committee for Civil Rights. There's a great HuffPost article. You can see the link there. And it's, if you just sort of Google HuffPost voting at Cook County Jail, you'll see this article. There's a wonderful 7-minute video that features this woman in the video. And on the second picture there is Jennifer Dean, Jen Dean, who works with Chicago Votes in Division 5, which is a women's division, talking to people before getting them registered. This interview with this woman really does give a great example of the engagement that people who are detained in jails have. I've been giving, and several colleagues of mine have been giving talks at Cook County Jail. We were giving these talks prior to the March primary. And I gave a talk to about 4 groups, 3 in the men's divisions and 1 in the women's division. And these women were very engaged, very informed. I should have brought my Intro to American Politics textbook with me. They had me going back and saying, I got to get back to you about this question. I don't want to go too far with this, but they were so much more informed than some of the men's divisions that I met with. And those guys were informed. So these folks, they're paying attention. Many of them are paying attention. A key problem, again, is that many are unaware of their voting eligibility. And so Corona notwithstanding, folks are still really trying to get out there and register people. And of course, like many voters, many folks in the jail found our ballots, our massive ballot, very daunting. The effort to learn about the issues, like many other people, can be very daunting. I think one of my favorite lines is I was registering somebody to vote or helping him vote, and he was studying the ballot really closely, and he looked like he didn't quite know. And he sort of muttered to himself, he's like, next time I got to call my mom before I do this. And, you know, I just had to chuckle because our parents are often our first teachers when it comes to voting. And so I said, well, that's the right thing to do. And so hopefully he was able to call his mom before the next election. And on that note, I am done. And I appreciate your attention to my ramblings here. It's been fun to talk about this. And so let's get back to some questions. Oh,
Yes.
One other thing before we get to questions. I'm sorry. I know, I'm classic. The woman in the slide here in the corner, the right-handed corner, these photos are from registering and then voting last March. The diagonal photos are from voting last March at Cook County. The wonderful woman in the right-hand corner is Michelle Mbekiyani Wiley, who is a lawyer with Cook County State's Attorney. And she was the one who initiated the effort to revive voting at Cook County Jail again, and after which Chicago Votes and the Chicago Lawyers Committee really took on a lot of the heavy logistical lifting for that. So I just want to call her out, Michelle Mbekiyani Wiley, for reviving this effort at Cook County Jail. Okay, now I'm done.
Dr. Rivers, thank you for that presentation. I'm going to just jump right in because we have several questions. Jose asked, how are some states still allowed to not allow felons to vote? And you started to touch on this a bit, so I don't know if you want to add anything additional. Oh, you're muted.
States have a right to disenfranchise those who are serving a felony conviction. It's entirely within their 10th Amendment rights to do this. So I think the question is maybe, perhaps not so much how they can do this, but maybe why they're still doing this in light of how this is becoming increasingly problematic given the racial disparities in incarceration and also the sheer numbers. In the 70s, there were maybe 750,000 people who were serving out a sentence in prison across the entire nation. And now it's closer to 2.3 million. And so that's really the best question I have, is it is entirely within a state power to do this unless a national law is passed to prevent that. And so far, that hasn't happened.
And I think as we're seeing even now, Dr. Rivers, there's a lot of power that states have that we didn't typically know of before. So Nate asks, recently, a U.S. Circuit Court of Appeals allowed the state of Florida to force people convicted of felonies to pay debts from their court proceedings before regaining their right to vote. Would you consider this a modern day example of a poll tax?
That's a great question. So to give a little background on that, in 2018, the Florida Rights Restoration Coalition, which was a bipartisan coalition of people with a felony conviction who were disenfranchised, mounted a campaign to put in a referendum on the ballot for voters at large to repeal the state's felony disenfranchisement law. Prior to that, two governors, Governor Christ in the mid-90s had revoked that law, had canceled out that law. And when Governor Scott came in, he not only reimposed the permanent disenfranchisement law, he made it even more difficult for people with a felony conviction to gain their voting rights. And so this bipartisan coalition did a really great job of presenting their case to the public. And Florida voters voted 64% to repeal Florida's felony disenfranchisement law. There were two carve-outs. So if you were convicted of murder or of crimes of a sexual nature, you remain permanently disenfranchised, but everybody else was reenfranchised. So that passed in November of 2018, and in January of 2019, so 2 months later, the state legislature put forth a bill to require those with a felony conviction to pay any sort of remaining court fees, et cetera, et cetera. That has been framed as effectively a poll tax. And the devil is in the details, and it depends on the wording, right? It can't be a poll tax. There's a constitutional amendment against poll taxes, at least for federal elections. But it has the effect of a poll tax, because how did the poll tax keep people from voting? If they couldn't afford to pay it, they couldn't vote. So it has the same effect, it has the same function, but it doesn't have the same name. So this has gone back and forth and back and forth. And the most recent decision came down last Friday that did not liken these fees to a poll tax. And so they upheld that state law. And those who are litigating this case, I spoke with a colleague about this just yesterday. They're trying to figure out whether they want to appeal it or what else they want to do with this. In the meantime, you have private donors. LeBron James has talked about coming up with a pot of funding to help people who want to vote to contribute to pay those fees. So personally speaking, I would say it's tantamount absolutely to a poll tax. It also, if you think about it, that law overrules the will of 64% of the people. And I have not read the 200-page opinion that came out on Friday. It'll probably be a while, but I would be interested to see what, if anything, that opinion says about how the legislature passed a law that overruled 64% of the people. So I would say it's tantamount to a poll tax, but formally it is not a poll tax.
Thank you for that response. Gretchen asked, in your opinion, who is the most influential leader of the women's suffrage movement in the United States? Why does her or his voice stand above others in the call to get women the right to vote?
So I'm chronically indecisive, Gretchen. That's a really difficult question to answer, in part because there were just so many outstanding women suffragists who were there from all stripes. And not all of them were perfect, but they were absolutely outstanding. So it's really, really difficult. You know, some people would say that it was Susan B. Anthony, because she fought for so long. She was jailed for attempting to exercise the right to vote. She knew she was breaking the law. She did it on purpose and was jailed. And of course, this was a tactic that was used again in the civil rights era. She was proud to be jailed. She was looking forward to defending herself in court. A gentleman bailed her out because he didn't want to see her, a lady, in jail. By all accounts, she was absolutely livid at being bailed out because she was really ready to make her case. in the court, and that in that particular moment it didn't happen. So many people would put her at the top. Many people would put Frederick Douglass at the top because, again, he was this ardent universal suffragist who in the end ended up having to decide after the 15th Amendment Reconstruction era. It was becoming clear that it was either going to be men who were being freedmen who were going to be enfranchised, or women, where he really saw this as a life or death issue with respect to enfranchising Black men, where it was somewhat less of a life or death issue for women to get the right to vote. You could argue one person I didn't talk about, but E.B. Du Bois, who was one of the founders of the NAACP, was also an ardent suffragist. I would go back and say Fannie Lou Haber. There's I think it was Alice Paul, who ran the National Women's Suffrage Association. There are those women who were beaten and force-fed, brutally force-fed, who were enduring a hunger strike to get their right to vote. So it's really a very, very difficult question to answer. I guess it would kind of depend, and this is a typically professorial answer, but it would kind of depend on how you define the best, right? There were a lot of heroes out there for suffrage, and many that I haven't even mentioned.
So Ibra has a two-part question. She asked, are felons able to register to vote? And can you explain what are potential ways for convicted felons to regain their right to vote? And I think you began to hit on this a little bit.
Yeah, it really depends on the state. If I'm blanking on the name, the National Conference of State Legislatures, has a great website and sort of a map and a matrix of which states, 48 out of 50 do disenfranchise. It has a map of what the barriers are and what the processes are. And it really does vary by state. It's hard. It's not even like there are 2 or 3 different ways, right? Some make you wait longer than others. Some it's a matter of just waiting over time. In some cases, you have to be done with parole and probation first. In other cases, you have to go before a judge or a magistrate to make your case to get the right to vote. In other cases, like Illinois, as soon as you leave the confines of the correctional system, even if you're still on probation or parole, your eligibility is restored. So it really does depend on the state. And it can be very, very complicated, just like registration can be very complicated for anyone, especially if this is your first time doing it, or you're moving to a different state where it's different. So it really does differ by state. But the most draconian, which was, I think was the case in Iowa, and at one point was the case in Florida, was having to appeal to the governor and meet with the governor in person to request your right to vote. You know, you can imagine how daunting that is, and also how much time that would take. And in the case of Governor Scott, he reversed, I don't think many more than 50 of those petitions out of several thousand people who petitioned for his approval. He didn't approve very many. He didn't hear very many of these cases. So it really is kind of a patchwork. So I would go to that website, National Conference of State Legislators. I think that's the name of it. They have the best, they have a good matrix. Also, the Marshall Project has information on this, and the Sentencing Project, and the Brennan Center.
Excellent. I think that this is going to kind of combine 3 questions. Vincent kind of folds into Mika and Anonymous. So Vincent's question is, should those with a felony charge that are still serving time be able to vote, or should it only be for those who have committed less severe crimes still serving time be able to vote? Should it be both? And so, Dr. Rivers, I think that one aspect is you talked about people who are jailed, right? They're eligible. But he's asking, should people who are actually been convicted, are they eligible, and should they be eligible? And if so, why?
Well, yes. In most states now, if you have been convicted of a felony and if you have served out your sentence at some point you regain your right to vote. This notion of regaining your right to vote after serving out a felony conviction is part of the restoration to society. When people serve out a sentence, they're convicted, they serve out a sentence, they get out of prison. What do we hear often? Where you're re-entering society. That's the term that we hear, right? And where are they re-entering from? They're re-entering from departments of corrections. If you look at the names of prison systems, more often than not, there's either correction is that in that name or rehabilitation or both. So the whole purpose, at least on paper, of prisons is to do two things: to punish, but to correct and to rehabilitate. And in theory, if you do that and you get out and you're ready to re-enter society, you don't have first-class citizenship if you can't vote. And so there's a gap. It's very difficult to re-enter society if you're not fully considered a member of that society. Now, for some people who are apathetic about voting, they're fine with it because they wouldn't have voted anyway. And 40% of Americans don't vote who aren't incarcerated, right? Our turnout rates are not stellar by any stretch. But if you believe in this notion of, doing the crime, do the time, pay your penalty, and then come back out into society and get that second chance, then having the right to vote and full citizenship should certainly be a part of that second chance. Otherwise, it's an incomplete form of citizenship. One of the things, the main mantras behind suffrage movements, whether it was a women's suffrage movement or the civil rights movement, and those were the two kind of big classic sort of suffrage movements, and to a very quick extent, the movement that was led by youth that got the amendment, I think it was the 26th Amendment, that dropped the voting age from 21 down to 18, was this notion of citizenship and being able to have a political voice and to make decisions that affect you as an adult. So to not have that right to vote that's the hallmark that's often been expressed is the hallmark of citizenship in this country has been the right to vote. So it falls along those lines. And again, when you talk to people who have been in this situation, again, not everybody, but a lot, they want to be able to engage in civic behavior and to come out and to do things to improve their communities. And they recognize that one way you can do this is to exercise your civil rights. So I say it comes part and parcel with reentry.
I'm just here going, yes, yes, yes. From a restorative perspective, I'm there. So,
yeah, you're a little there. One other thing I want to add too, by comparison, America is the only advanced democracy that disenfranchises people with a felony conviction at all. In other countries, and when I say advanced democracies, most of these are sort of peer democracies in Europe primarily, although some in South America, you'll see those counted. But of countries that are considered advanced democracies, they don't disenfranchise people with a felony conviction or people serving out a sentence by nearly the same rate. I mean, not even close, not even close. And there are some countries, nations that do allow people who are serving a felony conviction to vote, where they separate their crime from just their political voice. So we're really, really, really an outlier. The countries that imprison and disenfranchise at a similar rate as the US tend to be our ideological foes. So countries like Iran, Russia, and to a lesser extent China, and I think North Korea, our rates of incarceration and rates of disenfranchisement much more closely mirror those countries who for many years were considered part of the axis of evil and our mortal enemy, right? So it's an interesting irony that we are more in league with our ideological foes on this particular issue than we are with our ideological friends.
Do you believe that the mass incarceration of Black men and women was genuinely because of people of color could dramatically sway the US election?
Well, believe it's plausible. There's a reason that you had so many states in the South work as diligently as they could to the point of killing people to deprive Black people of the right to vote. And the reason was to maintain white supremacy in those states. That's pure and clear. And as those rights were regained and reaffirmed, and as Black people's registration rates started to really kind of exponentially rise in the 60s after the passage of the Voting Rights Act, you saw many more people of color, Black folks running for office, winning election, and changing laws and getting rid of those laws that discriminated against them. So, as I said in the very beginning of this talk, voting is power. And one of the biggest power dynamics in this country has been the Black-white binary. It's just how our history has shaken out, right? But in any other country you look at, voting is power. There's always going to be a dynamic where you're going to have one group that's really trying to suppress that vote, of a competing group. America didn't make this up. We just kind of have our own flavor, right? So if you frame this in a way that, where the question is, was this done to keep Black people disempowered? Yes, that's absolutely true. In the South, it's a little more diffuse once you get out of the South. But again, efforts to suppress votes, whether it's based on race or political party, these partisan battles that we see all the time around districting and voter suppression now that's kind of targeted at people's party. It's the same thing. It's a way of two parties in this case fighting for that ultimate power. And when you have these fights for power, the gloves come off. And in the case of Black voting rights, it's been a deadly struggle.
So this question follows greatly to that statement. Has there been any effort by politicians to court the votes of those who are incarcerated?
That's a good question. Not that I know of. I do remember the brief debate that Bernie Sanders was having with Pete Buttigieg about this. And Bernie spoke very openly about allowing incarcerated people to vote, which was not surprising because Vermont already allows that. And by the way, Massachusetts allowed incarcerated people to vote up until 2000, so fairly recently. And I remember when he first said that, I thought, oh, okay, who's he talking to? But I don't know I don't have any recall. I don't have any knowledge of current politicians or past politicians who have expressly sought out formerly incarcerated people to vote. I think what's going to end up happening is as more formerly incarcerated people regain their rights to vote, such as those in Florida, I think that people running for office will just recognize that they have a bigger pool of people to convince, and whether they're going to reach out to them as specifically as formerly incarcerated, probably not. What may end up happening is they may spend more time in campaigning in neighborhoods that may have communities that have a higher rate of formerly incarcerated people, but I don't know of any specific pitches for that. I'll have to look for that. I'm sorry, I can't answer that any better.
That actually is a great constituency base, I think.
A big base. So, we're talking 25% of the African-American population, and I think 10% of Florida's overall population had been disenfranchised by this permanent disenfranchisement law that they had. And in Florida, being a swing state as it is, with this reputation for these razor-thin elections, we may see that in Florida, but so far I haven't read about it.
And Dr. Rivers, this is our last question from our most engaged audience. I've enjoyed the questions as much as I've enjoyed your answers. They're pretty detailed.
Great questions.
So, do we have details about the ethnicities incarcerated under the white demographic? For example, Middle Eastern people who are forced to identify under said demographic. Just asking because I firmly believe this affects proportionality of imprisonment versus population. And I do have another question, Dr. Rivers.
Okay. It's From what I'm learning about data, and I'm not an expert on how departments of correction keep data, the one thing I'm learning about this is that the data is hard to get, and that often it's regular data, sort of generic data is not kept. It's a difficult task. One thing I can say, I don't know about Middle Eastern, but one thing I can say is, first off, they're going to kind of follow the census, and for decades, Middle Eastern, I think, was classified as white. I think now it has its own box. But what I have heard, this is anecdotal, what I have heard from people of Latino descent, Afro-Latinos in particular, who would present as African American, they would be classified as Black. But if you were Latino and were sort of more European presenting, that often they may be classified by the prison system as white. And so that may not be how they identify, but that may be how they're classified. And so I think that the way that prisons classify incarcerated people is very loose, for lack of a better term. Again, I'm learning, this is information that I've gotten anecdotally. My home state of California also comes to mind, where incarcerated people are housed and assigned, even on the yard where they're out there doing exercise, in 3 distinct groups, white, Latino, and Black. And it's sort of a divide and conquer kind of a format, and it creates a lot of tension. And so in California, one might argue that some people are classified certain ways, and they're not, just to kind of maintain this steady state of divisiveness, right? So I think it really depends on the state. I think it just depends on the personnel who are doing the counting and what criteria they're using, and that's information that's not really very easy to get. You might even need Freedom of Information Act requests to get this. It's a very opaque process that I just don't know that much about. So again, that's the best answer I can give to that question. I think what you might be asking is, is the prison demographic count corrupted to a certain extent by people who are misclassified or wrongly classified based on their race or their ethnicity? I would say, yeah, that probably is the case. But the degree of it, I have no idea.
So Dr. Rivers, we have just 1 minute for this last question. Can you please explain why voter ID laws are considered discriminatory, and how can we enfranchise voters that are in this category?
Ooh, how much time do we have? So voter ID laws, when they first came out, and the first state to pass a voter ID law was Indiana. They initially came out and a fee was attached. In other words, that fee to get that ID was, I think, initially something like $25, which is significant for populations that don't have a lot of money. And so this is typically historically economically disenfranchised minorities, younger people. This really affected students, especially first-time students who might be in college, and they're rubbing 2 dimes together to pay their rent. And also older people who are on a fixed income or a lower income. So very quickly, and this is also, I think, an issue in Atlanta, in Georgia. I'm sorry, so it was not an issue in Indiana, it was in Georgia. So that was very quickly changed, and so the fee was dropped down, I think, to something like $5, and over time they might have gotten rid of that fee. But to the extent that there's a fee required to get any kind of certification, that can have a disproportionate impact on racial minority groups who are already statistically have less money and less wealth and less income than whites. There are also sort of hidden costs to getting a voter ID. So maybe the ID to vote itself is free, but you may need to obtain your birth certificate to prove who you are. And sometimes the fee to get a birth certificate can be considerable. And especially if you're trying to get that birth certificate from another state. So there may be fees involved with, getting it mailed to you, especially if it has to be express mail, or just fees involved in getting that certificate. So the fees of getting a birth certificate can often be financially daunting or logistically problematic, especially now when so many of these offices are closed. I know our Secretary of State, it has a backlog on these types of requests, and it's becoming a problem. So there's a hidden cost there. There's a hidden cost of getting to the Secretary of State or to the DMV. So at one point in Georgia, many DMVs in Atlanta, the largest metropolitan area in the state with the largest Black population, had the least amount of facilities at one point where people could go get a voter ID. And so if you didn't have a car, and you had to rely on public transportation, which to get to these other DMVs was not very easy to do. It wasn't very frequent. It was quite far. That became a huge impediment. And so to the extent that the facility that you have to go to is far from you, whether it's you're in the city and it's way out there, or the reverse, you may be rural and you need to go into the city to get this, just the cost of getting out there can be insurmountable. And so one of the ways to make it easier is to have more facilities that are open, to not have any cost for the particular ID itself, to have minimal to no cost if you need to get your birth certificate, at least in that particular state. Perhaps to be able to figure out how to do this more online to make it a lot easier. One problem with elderly folks is there are many older folks who simply don't have a birth certificate. There's still people that are old enough who often don't have a birth certificate or have moved around a lot. Or let's say you're now a citizen, but you were born in another country and they're asking for your birth certificate. So it becomes very complicated, and it can be effectively very disenfranchising. So the more barriers you put up, even if they're not intended to be barriers, the more steps that you have to go through to register people, the better. Now, does that mean I'm saying, oh, I should just be able to go in and say who I am and I could be anybody, Mickey Mouse? No. But there are ways of making this easier. And so in many cases, in some states that have voter IDs, you don't have to get a state ID. You can use a picture ID that just verifies that it's used. So a student ID, for example, some states use that. In Texas and other states, if you have a gun owner's ID or a hunter or fishing ID, anything with your picture or work ID, often that's sufficient. So sometimes it just depends on how tight that ID requirement is. And again, that varies across the 33 or so states that have a voter ID law. That really varies. But one of the easiest things to do is just to widen the list of acceptable IDs that can verify that you are who you say you are.
Thank you so much, Dr. Rivers. We appreciate you taking out this time, and we're getting all kinds of feedback about how people should delve into their Constitution more. So I think they feel a bit guilty. I wanted to turn it over, though, to Dr. Robert Moorhead so that he can give our closing remarks. Dr. Moorhead?
Yeah, thank you for the fantastic discussion, and I really appreciated the lengthy engagement with all the questions. I also wanted to thank our morning presenters. If anyone missed our discussion this morning, be looking for a recording of it on the College of DuPage website. I want to thank Professors David Goldberg, Maureen Heffern-Ponicky, Sam Vitrani, and Missy Morrison, and also the talented moderation skills shared by Stephanie Quirk in Student Life. I want to pass it over to Sally Fairbank.
I want to join Robert in thanking the people who spoke so eloquently at noon today. And then this evening, Dr. Christina Rivers, you were awesome, engaging, enlightening, and we all learned so much. You can't put a program on like this without the collaboration of several other people. And we also want to thank the Office of Community Engagement, Amy Chambers, and Joanne DePiro, as well as Dean Marianne Honeycutt, and our fearless leader of our committee, Taya Forrest, who we wouldn't have been here today without her leadership and determination, especially since we had to move everything. Our earlier plans were changed because of COVID. And final thank you to the participants and the questioners. The questioners were really asking insightful questions that deepened our knowledge. So it was really a terrific evening for everyone.
And thank you again. It was an honor to be here. And these were great questions. Thank you so much.
Thank you, everyone. Have a great evening. Look for the link. We will have it present on the YouTube playlist, as Christine Kickles actually alluded to. Thank you so much. And we look forward to celebrating Constitution with you next year. But before you go, the Dialogue Over Distance Speakers Bureau has some exciting things in store for us. You always love an educational cartoon regarding politics. That's on Tuesday, October 13th at 7. Long Lines, Mail-in Ballots, and Election Outcomes. This will be quite interesting. As we all know, we're going to have a lot to speak about after the election. And then, of course, the December 15th event, Coattails or Chasms, local impact of the national election. Thank you again, and we look forward to you spending more time with us in these different circles. Have a great evening.